Welcome, everybody. Thanks for coming. Thanks for joining. Shared my screen here. Got everybody on mute at the moment. What I'd like to do is just go through the slides and go through the presentation, and then if anybody has any questions, we should have plenty of time to answer those. The presentation itself should be about 25 or 30 minutes, maybe. If you have questions as you go, I've got April from our office is on the call there. She's one of the brave souls with her camera on. And if you want to send her a chat, you can do that with a question. She can read those at the end, or if you just want to scribble it down and hold on to it, you can answer those when we get finished. The topic today is estate planning. We want to focus a little bit on digital assets, talk about what those are and things. My information's there. Obviously, I'm Glenn, Woods and Bates here in Lincoln. I'll put up our contact information again at the end. So I think it's good to start with a definition here. What is your estate? And your estate consists of the real and personal property that you own when you pass away. And those are the assets that your beneficiaries or your heirs are going to inherit after your debts are paid. So when we talk about estate planning, what we're talking about is planning for our ultimate demise. What's going to happen when we die? And what we want to do when we're doing that type of planning is ensure that your assets are passing to the appropriate people or entities where you want those things to go. And we want to do that with the least amount of tax implications. So I put together a roadmap of what we want to talk about today. First thing I want to talk about is a will versus a trust. What are those? What's the difference between those? What are the pros and cons of those? Then I want to go through some of the things that we talk about when we're meeting with clients, drafting estate plans, what information we need to begin that process, what information clients need to be thinking about and deciding. Talk about lifetime gifts, if we can give our assets away during our lifetime, and if so, what should we be thinking about if we're doing that? And then finally, talk a little bit about powers of attorney, what those are, what they do, why we think they're important, and then get into some of these digital asset issues that this presentation is about. So the first thing there is there's two different types of plans I want to talk about today. One is a will plan, will-based plan, and one is a trust-based plan. So the will-based plan revolves around a last will and testament. So the will is a document that's going to direct someone after you die how to distribute your assets or how to distribute your estate. And the way that works is that will gets admitted to probate, and probate is the court administration of the will. The judge says, yes, this will is valid. The judge appoints the executor, which is going to be nominated in the will, and that executor uses that will as the marching instructions to say, here's what I'm supposed to be doing to wind up the affairs of the deceased. Okay. We can also do things in that will, like nominate guardians if we have minor children. There's other things we can do with that will, but that's the basis of what the will can do. I'm going to differentiate that a little bit from a trust-based plan, which is focused on a trust. And in this case, we're talking about a revocable living trust. So there's all kinds of different trusts that you can have or create. This is a trust that somebody creates while they're alive. And in order for this trust to work and function the way we want it to, what we're going to do is we're going to retitle property that the person owns into the name of the trust. So whether that be by way of deed or changing the ownership on a bank account or beneficiaries, whatever we need to do, we're going to retitle assets into the name of that trust. This type of plan does not negate the need to have a will. So if somebody created a trust, in this case, a revocable living trust, they would have a will that's called a pour-over will, is what we commonly call it. What that will says is I leave everything I own to my trust. Now, if we're doing this correctly, we want to avoid probating that will. but that will acts as a safeguard to get assets to the trust. If something changed, something happened, and those assets weren't owned in the trust, they were owned by the deceased individually, everything is going to still go where we want it to go. But like I said, we don't want to use that will, because that's just going to add a step in this type of planning. There's pros and cons to each. But if somebody dies without some sort of plan in place, that person is known to have died intestate. So their assets in that case are going to pass according to the laws of the state of Illinois, which in our experience is not a preferred plan. So we want to avoid that. We want to do some pre-planning. Okay, so this spreadsheet talks a little bit about the pros and the cons, if you will, of a will-based plan, which is on the left side here, versus a trust-based plan. So this first section talks about when the person is living, and in a will-based plan, there's going to be some lower cost up front to create it. There's going to be some lower time commitment. Like we talked about, that's going to be marching instructions for your executor. Here's what I want you to do when I die. A will does not delegate any control of your assets during your lifetime. Whereas on the right side over here, when we talk about a trust has a little higher upfront cost to create. One of the reasons is because it has a higher time commitment. There's some things that you need to do to retitle assets to make that trust work. We want to make sure that it's adequately funded. One of the benefits of the trust also is that the trustee or successor trustee, whoever has control of those assets, would have control of them if you were to become disabled while you were still living. Okay. So then we look at after death. In a will-based plan, there is going to be court involvement. That will is going to be admitted to probate, like we talked about. Executor is going to be appointed. There's going to be higher cost of administration at that point because it's going to be more time consuming. There's notices that would go out. There's requirements on the executor that they have to follow, boxes they have to check. Could potentially be some delay in getting that executor appointed. That delay where we live is not horrendous. You know, you're talking about a couple weeks. If you get up into counties like Cook County, that could be months. So there could be some delay there. There's no privacy within the state administration. Those records are public. If somebody wanted to look at those, they certainly could. Whereas in a trust-based plan, we're not going to have any court involvement. So that successor trustee is going to be nominated in the document. They're going to be vested with authority automatically when the person that created it dies. Hopefully, if we've done everything properly, we've funded the trust correctly, there's going to be minimal cost, minimal time commitment to administer the trust, distribute the trust, whatever we need to do. Again, if we're properly funded, there's not going to be any delay in this process. And that trust document's going to be totally private. The only people that are going to see it are going to be beneficiaries, trustee. If we have creditors, they're going to be able to see it also, but there's some privacy there. One of the things we talk about, whether we're doing a will-based plan or a trust-based plan, is ownership of assets, beneficiary designations, and those things become very, very important when we're talking about estate planning. The reason those become important is because ownership and beneficiaries, transfer on death, payable on death, whatever the case may be, is going to take precedence over what a will says or a trust says in that case. So for instance, if I own a piece of real estate jointly with rights of survivorship with my sister and I die, she's automatically going to own that asset just by way of our ownership. So even if I had a trust or I had a will that said I leave everything I own to my wife, because of that ownership, that's not what's going to happen. My sister is going to be the owner of that. Same thing with beneficiaries. If I list a beneficiary, let's use my sister again on a life insurance policy, and I have that same will that says I leave everything I own to my wife, my sister is going to be the beneficiary of that life policy. They're going to write her a check when I die. Does not matter what my will says. So these are important things to keep in mind when we're doing planning. We want to make sure that all of our asset ownership, all of our beneficiaries, all of our transfer on death information is in alignment with the plan that we're creating. This can change, if we have changes in life circumstances, birth, death, marriage, disability, things like that. We want to be reviewing this from time to time to make sure it's still updated. One of the things that's going to be on the next slide that we talk about when we're doing planning is tax related issues. So is there going to be an estate tax that we need to plan for? And how is the best way to plan for that tax? So in order to determine whether or not there's going to be a tax that we need to plan for, we look at the total gross taxable estate, which is here at the top. Total gross taxable estate is made up of everything that a person owns when they die. So I've differentiated here on the chart between what we've called non-probate assets here on the left and probate assets on the right. So probate assets are pretty simple. Those are assets that the deceased individual owns in their own name only. They don't own it jointly with anyone else. There's no beneficiaries, no payable on death. These are the assets that are going to be subject to the probate process we talked about a little bit ago. So the will is going to say, here's where these go, or in the absence of a will, there's going to be default rules. The state of Illinois says, here's where the assets are going to go, or here's who your heirs at law are. Non-probate assets are all those other things. Those are the assets that aren't going to go through probate. They're going to have a joint owner. They're going to have a beneficiary. In the case of a trust, there's going to be trust beneficiaries. As you can see, those are the people that are going to inherit those assets. So when we talk about the gross taxable estate, we calculate the value of all of these assets. And then we see, okay, is it above or below the estate tax exemption amount? When you're talking about estate taxes, there's two systems. In Illinois, there's a state estate tax, and federally, there's an estate tax. The estate tax exemption amount in Illinois is $4 million per person. Federally, the exemption amount's much higher. It's $13.61 million. So if the total gross taxable estate is above those thresholds, there may be some different planning we need to do to try to avoid some of that tax or mitigate it. So when we talk about considerations, that's the first one there, estate tax. We do that by asking that a list of assets be compiled. We want to look again at the ownership, at the beneficiaries, make sure that everything's going to go to whom or where we want it to go. Got to think about who those people are. Who do I want to inherit? Do I want to give, charitable gifts? Do I want to give everything to my children or my spouse or other people? So where do I want those things to go? Are there specific entities that I want to inherit, or do I want to give gifts to? Do I need to protect any of those beneficiaries from themselves? So when I say that, I talk about the most common would be minor children. Do we need to protect them? Do we need to create some sort of trust for them so that somebody's going to control an inheritance longer than age 18? Maybe we don't want them to get a large inheritance at age 18. Do I have beneficiaries that are spendthrifts? Does somebody need to control those assets so they don't blow them immediately upon receipt? Do I have beneficiaries that may be disabled? Do I have beneficiaries that may have addiction issues, things like that? So those are things that we talk about and think about. And then who do I want to fill some of these roles? Like executor, trustee. We'll talk about agents on powers of attorney. And we think it's a good idea to have at least one successor to those people, so that if the person that you've nominated can't act, you have somebody waiting in the wings to take over. So those are all some considerations there. If the person has minor children, we have to think about who we want to care for those minor children. State of Illinois differentiates, when we talk about guardians, they differentiate between guardians of the estate, guardians of the person. Guardians of the estate are going to be who's going to deal with assets that the minors come to own or do own. And then the guardian of the person is going to be who's going to care for these kids day to day, who's going to be running them to school, taking them to the doctor, telling them to brush their teeth 7 times a day, whatever the case may be. That's going to be who's going to care for those kids. Again, we kind of talked about this. Do I need to create a trust for these minors? Some considerations there. How long do I want the trustee to hold those assets? Do I want them to pay it over time? Do I want them to hold it for the lifetime of those children? Those are all things that we have to think about. And then who do I want to make specific gifts to, if any? We have to put those in the documents also. So that kind of leads into, if I want to give what I have away when I'm alive, can I do that? Short answer is yes, absolutely. If you own something, you can give it away. You can do whatever you want with it, but it may or may not be without consequence. So there is a rule that says any individual can give a gift in any calendar year to any other individual in an amount that doesn't exceed $18,000. And if they do that, they're not required to file a gift tax return. If the gift is valued at over $18,000, it would require a gift tax return to be filed. There's not going to be any tax due when that return's filed, but it could create some unintended consequences. One of those consequences is if you give a gift that's over that amount and you file that gift tax return. We talked earlier about estate tax. The value of that gift would come back into the estate of the gift giver for purposes of calculating the estate tax. So in the estate tax realm, the gift giver has not necessarily divested themselves of that asset when we're talking about those estate taxes. There's some issues about cost basis. If the recipient of the gift, who they're receiving it, they're going to receive the tax basis of the donor. So if they turn around and sell it, they may have a capital gain. Whereas if they inherited it through an estate or a trust or something like that, that recipient would get a step up in tax basis to the value at date of death of the gift giver. So there could be some considerations there. We may or may not want to do it that way. There's also potentially some Medicaid issues with gift giving. The $18,000 threshold is out the window when you start talking about Medicaid. Medicaid is a social welfare program. Most typically, we discuss that when we talk about long-term care. If there's a potential that is going to be necessary when you apply for that Medicaid assistance, they ask if you've given any gifts in the last 5 years or 60 months. And if you have, that's going to create ineligibilities for Medicaid. That's a whole different ball of wax, but it's worth mentioning. So then there's powers of attorney that we also discuss when we talk about estate planning. We wrap this in the discussion of estate planning. Everything we've talked about at this point is what's going to happen after I die. Powers of attorney are geared toward what's going to happen if something happens to me while I'm alive, or if I can't deal with my assets while I'm living. Who's going to do that? And we think this is an important discussion because anybody that's signing a power of attorney has to be competent, just as they have to be competent to sign a will, sign a trust, whatever the case may be. And all too often, it's too late when these documents are needed. So there's 2 documents that we routinely draft. There's a property power of attorney and a healthcare power of attorney. The property power of attorney nominates an agent. That agent's going to be able to transact business on behalf of the person that's drafting the document. That's either going to be out of convenience. So I'm out of the country, agent, I need you to go do this. Or necessity, I'm in a coma and I need you to go transact business, pay bills, things like that. Healthcare power of attorney is going to nominate an agent. That can be the same person or it can be different. that agent's going to be able to deal with doctors, hospitals, medical records, things like that if you become incapacitated and can't make those decisions for yourself. Wrapped up in that healthcare power of attorney are life-sustaining treatment decisions. Sometimes this is referred to as a living will. Those are sometimes separate documents, but those decisions can be wrapped up in the same document, whether or not you want to be kept alive by artificial means. If not, who you want to make those decisions if that time came. So these are important documents also. So here's just a little example for you. We talked about the estate tax exemption amounts in Illinois, 4 million, federally 13.61 million. Those are approximate effective tax rates, but the calculation of the tax is fairly complicated and probably not worth getting into at this point. So let's just say that the approximate cost of planning is $3,000 to $7,000. If you had somebody that had a $5 million total gross taxable estate, the Illinois estate tax on that estate would be approximately $285,000. If there's things that we could do to help with that tax or mitigate that tax, it seems that the cost of that planning is well worth it. On an estate that's $8 million, somebody dies, they had an estate of $8 million. Illinois estate tax on that estate is going to be about $680,000. If we had a married couple that had total assets of $8 million, there's planning that we could do where that tax would be zero. So the beneficiaries of that estate of the final spouse to die would be paying zero tax versus $680,000 in tax if there was some planning done to mitigate that tax. So there's certainly some unintended consequences of not planning. It's not really going to affect the person that died, but it's certainly going to have a pretty drastic effect on the beneficiaries. As you can see, that tax goes up dramatically when you start increasing the value of the estate. So now we have what I refer to as typical assets like bank accounts, all these things, real estate. We live in a world now where we all own what they refer to in the statutes as digital assets. Illinois has a definition of that, which I've typed out there. It's an electronic record in which an individual has a right or interest. So these digital asset statutes apply to all of our executors, our administrators, our trustees, guardians, agents, whatever the case may be. And so we have to make sure that we're giving these people appropriate authority to deal with these things. So what are digital assets? A couple examples that I came up with were email accounts. All of us have email accounts. Those are specific to us. We own those for the most part. If you have a work account, you may not own your work email account, but you certainly own your personal email account. Facebook accounts. We all have online photo albums. We're taking pictures with our phones. We own those photos on the phones. Some people have things like Bitcoin. A lot of our assets these days are digital. So bank accounts are digital. Investment accounts are digital. All of these things are online. They have usernames, passwords. So how do we deal with this? There's a couple different ways you can deal with this, just like you can deal with your assets in different ways. I would call your standard typical assets. You can deal with some of these digital assets with user direction. So this is a screenshot here of a page on a Facebook account. Facebook, along with some of the other social media accounts, will allow you to set things up within the account to either nominate what they call a legacy contact, or you can say, you want your Facebook page to be deleted if you die, or you want your Facebook page to be memorialized. And in the case of Facebook, when they talk about a legacy contact, that's going to be somebody that's going to be able to deal with your account when you're gone. So I assume the way that this would happen would be Facebook would want some sort of proof that you died, whether that be a death certificate or obituary, whatever the case is. And then they're going to give your legacy contact access to that account to deal with it. And then your legacy contact may have some direction, or they may decide, okay, we're going to make this a memorial account, which that changes it to a page where people can still interact with it. You know, they can say, we miss you, you know, whatever. Here's a picture of your dog. Things are still going well. I don't know. But they could also delete it, you know, so it's not there anymore. And this is within the account. So they're giving you the ability to do that. You know, I think of this like putting a beneficiary on a life insurance account. That's within the account. So that's not, a will's not doing that. A trust isn't doing that. You're doing that within the life insurance account. If you can't deal with it in that fashion, or you haven't dealt with it in that fashion, it's likely that your job holders, you know, like your executor, your trustees, your agents, things like that, may have to deal with these things. So what the rules in Illinois say are those authorities have to be in writing. So those have to be in the will, or they have to be in the trust, or they have to be in the power of attorney to give your position holders the requisite authority to deal with those accounts. So for instance, if I've put that in my will, I've said I authorize my executor to deal with my digital assets, you know, and lawyer that up a little bit, put some mumbo jumbo in there for everybody to read. They would have the requisite authority to deal with those things. So if they needed to access my email account, they could use that document to do it. You know, they're going to be able to contact Google or Yahoo or whatever the case and try to get access to that. I'm not saying it's going to be easy, but without that written authority, the statute says you don't have the ability to access it. So this written authority can override contrary provisions, terms of service agreements, things like that. That's what the case law has said thus far. So, you know, like terms of service in a Yahoo account says you can't transfer this to anybody else or anything like that. The courts have said, well, you know, the executors should be able to deal with these things. We have to get access to these things. And here's just a short example of why that may be important. Okay, so let's say I was the decedent. While I was living, I went out, I had to purchase a new furnace, and I made that purchase. I financed that through my bank. So while I was alive, I was receiving monthly email reminders from the heating company. Hey, you owe us your monthly payment. Or from the bank, I guess in this case, they would be saying your payment's due. I went into my bank account. I set up an automatic payment, and every month that just came out. It was paid. I didn't have to worry about it. My bank account, I get online statements, so I get those via email. How's anybody going to know this is happening after I die? So historically, what would have happened would be the executor, once they're appointed, or the trustee, whatever the case is, they would go in and they would have the person's mail forwarded to them. Okay, so they're receiving the mail. A month goes by, they get the statement, they see, all right, we've got this debt out here. We're going to have to deal with this debt in the estate some way, shape, or form. We need to be making these payments because this furnace is, you know, attached to the house. We've got to protect the house. So then they would do that however they needed to. In this case, they're not going to know that's going on unless they have access to my digital assets. So they need to have access to my email account, get those emails forwarded, or they need to have access to my bank account to see what's coming out every month. These are the things we need to deal with. And the way that they're going to be able to do that is with the written authority in the document that gives them the power. So the will or the trust or the power of attorney, what have you. So this is obviously kind of a break from the way things have always been done, but this one's mind-boggling. But this is something I found when I was looking through this. This is what's called a non-fungible token. Okay, so this picture over here is the non-fungible token. This picture, this digital work of art went up for auction, and this has been a couple years now, but this thing sold for $69 million online, and the winner got a digital file. So they got one of one digital files. I don't know what they do with it. I don't understand it totally, but they now have a digital file that they've paid $69 million for. How do we know this is there? So if we don't have appropriate instruction, or we don't have some sort of asset list from the person who's died telling us, look, I've got this non-fungible token, this could totally get overlooked. And you've got a $69 million asset there. Now, I'm not saying you're going to be able to resell it for that, but it obviously has some value to someone. So I came up with some best practices. These are pieces of advice that we give routinely to clients when we're doing estate planning. One of the things that we've always recommended is that we review documents. Annual basis is kind of our rule of thumb, or whenever there's a change in life circumstances. So birth, death, divorce, disability, all the big ones. One of the things that we think is really beneficial is for clients to create an asset list showing ownership, showing values, showing beneficiaries, where are these things located. This is going to serve a couple purposes. It's going to show, do we or do we not need to plan for estate tax issues while we're alive. It's also going to help out an executor or a trustee knowing what's going to need to be dealt with when that person dies. If you don't have a listing of these things, you're going to start your scavenger hunt, and you're going to have to find out, well, what was it that they owned? How was it owned? Where's it owned? That type of thing. So that can be really, really burdensome at a time that is not real fun anyway. So in addition to that, we've started advising that we make a list of online accounts and passwords. And with everything, we need to make sure that somebody else other than the person that's doing the planning knows where to find these things. So should we keep this with our will? Is this a separate app or a separate document on the server that we've saved, that we've created this list of accounts and passwords and things like that? And all this is going to do is this is going to help your administrator or executor or trustee access these things when they need to access them. Because even if they have, the proper written authority in their documents, it's going to be a lot easier if they have the username and password, because they'll be able to get in there and they'll be able to deal with it right away. And then, obviously we want our documents to be giving the appropriate authority to deal with digital assets if it becomes necessary. Okay, so obviously everybody's circumstances are different. We need to tailor an individual's plan to meet their needs, meet their goals, meet their expectations. We want to be reviewing that. We want to make sure that it's current. A plan that was made in 1985 is not necessarily going to be what we want to have happen in 2024. So again, with those big changes in life circumstances, we want to make sure we're reviewing the plan, make sure that it's current, make sure our assets still align with the plan. If we've bought or sold assets, do those need to be titled in the name of the trust? Are they owned appropriately? I think it's a good idea for everybody to make their wishes and desires known while they're living. This helps to avoid confusion, helps to avoid feuding. And when we have confusion and feuding, we have litigation and attorney's fees. We don't want to have that. So I'm happy to answer any questions at this point if anybody has any, or if anybody is sending any to April. Happy to schedule a time to discuss. If you want to discuss any of these things further, we can. If anybody wants to make appointments today, I can put you into a breakout room if you want to hang out when we get done, and April can set you on the path there, or we can get in touch. Our phone number's on the screen there, but thanks again for coming, and take any questions you have.
Good morning, everyone. I have a question. Someone asked, can I write my own will?
You can. So there's a caveat to that in Illinois. You can write your own will if you feel comfortable doing that. However, the will still has to conform to the requirements of the state of Illinois. So the state of Illinois says it has to be in writing, has to be signed by the testator, the person creating the will. It has to be witnessed by 2 independent witnesses. The person signing the will has to be competent. They have to know what they're doing, who their heirs are, that type of thing. Sometimes you see what they call holographic wills. Holographic wills are wills that people have handwritten themselves. In some jurisdictions, those are valid. In Illinois, they are not valid. So if you just wrote down on a piece of paper, this is my will, this is what I want to have happen, and signed it, that is not a valid document in Illinois. So yes, but it still has to meet the requirements of a valid will in Illinois.
I think I have another question. How difficult is it to make changes to a will or a trust?
It's not too difficult anymore. Used to be more difficult than it is now. There's a guy on the call that could probably speak to that more than I could, but with word processing, we can make changes pretty easily to documents that we've drafted. Most of the time, if somebody's going to revise a will, for instance, we will draft a new document. The new document would revoke the old document once it's signed and executed appropriately. We still do amendments to trusts, pretty regularly, but you could do a restatement to the trust fairly simply also with word processing. So it's really not as difficult as it used to be. And, that's the beauty of planning, is as long as you're alive and as long as you're competent, it's not set in stone, unless you start dealing with irrevocable trusts or things like that. But I didn't get into that today, so I'm not gonna bore anyone any longer.
Okay, thank you. Here's another question. How long does the estate planning process take?
So the process itself, I'm going to stop sharing my screen here. Process itself kind of depends on the client, but just in general, once somebody calls to make an appointment, I would say we can probably get through everything we need to do within a couple weeks, 30 days, something like that. So we would typically schedule the appointment. We would send some information and ask the client to fill out some information in advance of that appointment. Then meet with the client and come up with, here's what we're going to do. Here's the plan that we're going to create, and then send some draft documents to the client to review, make any changes, and then have the client come in and sign original documents. And that's kind of the process. So if we can get that done relatively quickly, we can do it. If not, sometimes clients take a little bit longer than others they want to review them. They just haven't had the time to sit down. So it's really dependent upon the client, but I would say 2 to 4 weeks would be good rule of thumb on that.
Okay, and I think we have one more question. I've always thought trusts were just for wealthy people. If we have a basic house, car, and a 401k, do we need a trust?
I think it kind of depends on, what the goals are and what we're trying to accomplish. So if there's somebody that owns real estate, for instance, and they want to avoid probate, that may be the way that we accomplish that goal, is to create a trust and put assets in the trust. The trust itself is not necessarily just reserved for people with an abundance of wealth. It can be a pretty nice tool to avoid probate, can be a nice tool to have some privacy, make sure that things are going where we want them to go, that type of thing. So I don't fully remember the question. I think I answered it, but it's not necessarily reserved for the ultra wealthy.
All right, thank you.
Thanks again for joining us, and hope to see you soon.